Good morning, friends. My today's topic is critical analysis of Section 319 CrPC. Section 319 deals with the power of the court to proceed against other persons appearing to be guilty of such an offense for which the accused is prosecuted. There are cases where, after the production of evidence, the court thinks that a person other than the accused has committed the offense. In such cases, the court has the power under Section 319 of the Code of Criminal Procedure to summon, detain, or arrest such a person after the service of notice. Now, the Section 319 CRPC takes into consideration the interests of the person who has been joined as accused, as the Section 319 subclause 4 says so. I can say that this section talks about additional prosecution. When during the trial it appears to the court that a person who has not been joined as accused in the case has committed the offense, then in such a case, the person can be tried together with the accused. So this section 319 ensures justice and takes into account the convenience of both the parties by taking cognizance of the newly added accused in the same case. The bench of Justice K.M. Joseph and P.S. Narasimha reiterated the findings of Babu Bhai, Bhima Bhai, and versus State of Gujarat, that is of 2014. It said the power under Section 319 cannot be exercised in a casual and cavalier manner. It should be exercised only when strong and cogent evidence occurs against a person. This Section 319 emphasizes the principle of double jeopardy, which has been enshrined in Article 20, Subclause 3 of the Indian Constitution. The Supreme Court reiterated in Manjeet Singh versus State of Haryana 2021 that once the accused has been acquitted, he cannot be summoned as an additional accused. It is based on the principle that the culprit must not be acquitted and accused must not be punished. Now, before going further, coming to brief summary of the section 319. This section 319 deals with additional prosecution. It mandates the court to add any such person to the trial with the accused against whom strong evidence has been presented. Such a person against whom sufficient evidence has been produced and the court is satisfied as to his involvement in the case becomes an accused on the date when the order has been passed by the court. The magistrate has ample powers at any stage of inquiry or trial to take cognizance and add any such person against whom prima facie evidence has been given. Even if the complaint has been dismissed under Section 203 CRPC after the inquiry is completed, it does not bar the court from initiating the proceeding under Section 319. Now, there are few rules, you can say essentials of Section 319 CRPC. These are: there must be trial or inquiry of an offense. Court, court must be satisfied by the evidence presented that any other person other than the accused has committed such an offense. Such a person has to be tried together with the accused. Now I will discuss a case, that is Sugriv Kumar versus State of Punjab and others. It is of 2019. What the court said in this? Court must be satisfied by the evidence presented that any other person other than the accused has committed such an offense. In a recent judgment which I quoted in 2019, the Supreme Court in Sugriv Kumar versus State of Punjab and others, a judgment was authored by Justice Dinesh Maheshwari for himself and Justice Abhay Manohar Sapri, and reiterated that to add a person as additional accused under Section 319 of the CrPC, stronger evidence is required than mere probability of complicity of that person. This is the test that's why to be applied while considering an application under Section 319. It is settled law that the evidence implicating the person must be cogent evidence and such power must be used by a court sparingly. And there were guidelines laid down in Hardeep Singh versus State of Punjab. This case is of 2014. The test which was laid down by the court was one which is more than prima facie case as exercised at the time of framing of the charge. What short of satisfaction to an extent that the evidence, if it goes unreverted, would lead to a conviction. The court further clarified that the power under this section is an extraordinary and discretionary power and has to be used sparingly by the courts. Unless the court is satisfied with the involvement of the person, it should not issue a summons or detain him. Now, the question is by whom can the power under Section 319 CRPC be exercised? This power conferred by Section 319 CRPC can be exercised by the courts. It can be exercised either suo motu or upon application by any person, including the accused. This power is discretionary and must be exercised judicially by the courts. The court enjoys extraordinary power under this section and it must be used sparingly. Only if evidence compels the court to initiate the proceeding against that person. The trial court can take suo motu cognizance only when there is evidence recorded during the trial, which involves the person to be added as accused, and evidence recorded during the investigation should not be relied upon. The power of the court of taking suo motu cognizance cannot be interfered with by the revisional courts only if the court gave cogent reasons while giving such an order. Such order must be given only when the first informant or one of the witnesses seeks to implicate a person other than the accused. Now question is what to do if trial court rejects application more than once. One is requesting for inclusion of more persons, addition of more persons under this section, but the trial court is rejecting again and again. Then there is solution in our legal system for every problem. When the court rejects an application more than once on the ground that no prima facie case has been made out, then the revisional court must hear the application under section 401 subclause 2 of CRPC. And if satisfied, the High Court can exercise its power under section 397 CRPC. What the question is, can we go directly to the court under 482 CRPC? The Supreme Court had said that when alternate provisions are there, then this section 382 CRP should be sparingly used. When it can solve problem under section 401 right with 397, then it is sufficient to use that power. Now, the question is, against whom can the power under section 319 CrPC can be exercised. The court can exercise this power against any person who has not been accused in a case before it. This does not include a person against whom such court has issued summons, but includes persons against whom the police investigation was dropped, but evidence shows prima facie involvement. However, if a person has been discharged, no proceeding can be initiated against him unless under section 300 subclause 5 CRPC or any higher court decides to try him. The question of whether a person who has not been named in the charge sheet can be prosecuted under this section, this has been answered by the courts in the affirmative. Even if such a person was accused in the FIR, but the police could not collect cogent evidence against him, still he can be added as an accused. Moreover, the accused against whom proceedings have been quashed can also be prosecuted under this section. Now, question is stage at which power under section 319 be used. It must be exercised at the trial or inquiry stage. The trial begins once the charges have been framed. In the case where the charge sheet is filed, whereas when the police files a final report, an inquiry by the court takes place. Trial means a determination of innocence or guilt of the accused by examining witnesses and documents. Whereas an inquiry commences after the police files a final report dropping all the charges against the accused person. In such cases, the court may initiate a further inquiry into the matter if it thinks it fit or if the other party files a protest petition. Now, there is one case that is Hardeep Singh versus State of Punjab of 2014. This court in Hardeep Singh versus State of Punjab 2014 has put a restriction on the power of the magistrate provided under section 319. It clarified that the magistrate is forbidden to exercise its power when the case is at the stage mentioned in section 207 to 209 CRPC. The magistrate cannot take cognizance at this stage of the proceeding. Now, again, this case is Ranjit Singh versus State of Punjab, 1998. The question as to whether the Court of Session has the power under Section 319 to summon the additional accused before the stage of recording evidence has been considered by the Supreme Court in Ranjit Singh versus State of Punjab. Honorable Supreme Court observed that once the Session Court has taken cognizance to the power to add any person as an accused can be exercised only after reaching the stage of evidence collection and not before that. Now, another case is Sraba Reddy versus Puthur Rani Reddy. This is of 2007. The power under section 319 ceases to exist with the end of trial, that is pronouncement of judgment. All the witnesses must be cross-examined before implicating him under section 319. Prima facie evidence is sufficient to implicate a person and initiate proceeding against him. Cross-examination is not a prerequisite to summoning an accused under section 319. These power could be exercised by the court upon completion of an examination in chief. The court in Sraba Reddy versus Puthur Rani Reddy has held that plea of alvi does not discharge the person and he can still be summoned under this section. Now, another case is Rajendra Singh versus State of UP. This is older one of 1959. The precedent set by the court in Rajendra Singh versus State of UP clarified the documents which could be relied upon for summoning a person under Section 319. It held that the material evidence which has been laid before the court has to be taken into consideration and not the case diary or charge sheet or affidavit or statement recorded under Section 161 CrPC. It was held that adding an accused merely on the suspicion of a witness would be a traversy of justice because hearsay evidence cannot be made admissible in the court of law. Is prior notice to accused is necessary? As a general rule, criminal courts are bound to issue a notice of summons for the appearance of a person in the court. The court must issue such a notice for adding the person as an accused only when it is satisfied that evidence implicates the accused. He must be given an opportunity of being heard, only after which the order under Section 319 can be passed by the court. Now, can there be a limitation period to add a person? Courts are not bound by a limitation period. The courts have clarified their position in cases where the trial court has already taken cognizance within the limitation period, but the application under Section 319 has not been passed for 3 years. Even then, the limitation provisions would not apply to the procedure laid under Section 319. The court's power under Section 319 are not bound by the limitation period. Now, there are so many case laws surrounding Section 319 CrPC. First was Hardeep Singh versus State of Punjab. Second one is R.C. Kumar versus State of AP. Suman versus State of Rajasthan. Sukhpal Singh Khera versus State of Punjab. Latest, this is case of 2019. So, coming to the conclusion, although almost all aspects of Section 319 CrPC are well settled, there remained a lacuna in some aspects of it. In a recent case of Mr. Sukhpal Singh Khera versus State of Punjab of 2019, Criminal Appeal number 866 of 2019, the Supreme Court pointed out a few points for which no precedents exist. Which are those points? The court emphasized that no guidelines have been laid down for the courts to follow while exercising its power under Section 319 CrPC. Although the power under this section is discretionary, it must be used sparingly, and in the absence of guidelines, it gives room to arbitrariness. Other lacuna on which the court stressed on was, although the precedents have laid down that the stage until which a new accused can be joined is only till the trial or inquiry stage. What happened when the trial of the accused is complete and judgment is pronounced on the same date along with the summoning order of the new accused? There is no precedent affirming or denying this position. These questions still need to be addressed in the court of law. Uh, Friends, there are few questions by my few friends who had already subscribed my channel. So I will try to give reply of to few of them if possible. You can also send me on my mobile any question. I will reply in next video. But the few question which I have received is the Mr. Dhanoa from Roper. He says Once the magistrate finds that there was sufficient material available in record before it to summon a person in the trial which is proposed to be undertaken, then the power under section 319 CrPC can be invoked. Yes, it can be invoked. No, no doubt in it. It can be invoked. Second question is from Arjinder, New Delhi. Can the specific evidence against the petitioner summoning under section 319 Criminal Procedure Code as additional accused proper? Yes, if that is there, then it is good. It is more strong case to summon them. They, he has asked that this is Mr. Raj from Bathinda. He's saying that power under section 39 of CRPC can be used ordinarily. No, no, no. It is to be exercised sparingly and only in appropriate cases, not in a routine manner. Now, it is Sunil from Amritsar who is asking power under section 319 of the CRPC can be exercised at what time? Mr. Sunil, it can be exercised at any time after charge sheet is filed, but before pronouncement of judgment. In between, it can be exercised. Now, the next question. The question is the person was booked under section 307 of the IPC and summoned under section 319 Criminal Procedure Code and accused found innocent by police but summoned again by the court. Can he be allowed anticipatory bail? Yes, these are two different things. Summoning an accused and additional accused is different thing, and the anticipatory bail has its own parameters, and it depends upon the gravity of charges. Just he can apply for anticipatory bail. Now, the next question is by Anil from Ludhiana. He is saying that order of the trial court judge refusing to summon a person as additional accused under section 319 Criminal Procedure Code. What can the aggrieved party do? The aggrieved party has remedy to file a revision under section 397, read with section 401 of the CrPC, and petition under section 482 Criminal Procedure Code is not maintainable. This is the finding of the Supreme Court of India of 2013. I will give you the case title in which it was decided. Let me. This was the case was Monu Sonu versus State of UP, and the criminal appeal number is 841 of 2013. So, friends, this is all about of this section. 319. I will like to welcome you all who spared time, and I will request you, whosoever have any question in mind about this section 319 or other section which I have covered in my videos, you can call me, or it will be better to WhatsApp me. My mobile number is, cell number is 9880722363. I am Ashok Roda Advocate from Chandigarh. Thanks for watching once again.